What happens when you pass away without a will? Your assets will get distributed per the intestate laws of your state. As an example, in Georgia, your assets get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3 of your assets. Now, it's likely that you wanted your spouse to get all of your assets so that they can financially take care of themselves for the remainder of their life, but it's likely that without instructions for them to get your assets, that they will financially struggle for the remainder of their life. So in this video, we're going to talk about the strategies that we would use to avoid the probate process and make sure our spouse gets all of our assets. And then we're going to talk about what the probate process looks like for your family if you do pass away without a will. And so the ways that we can avoid the probate process and pass our assets directly down to our spouse is going to be a will, joint tenants rights of survivorship, or a revocable trust. And we're going to talk about the reasons that you would use each one. With a will, you can give direction that your assets will go to your spouse when you pass away. The problem with the will is that your assets will have to go through the probate process before they can be passed down to your spouse. And the probate process can take 1 to 2 years, depending on the complexity of your estate, and it can cost $5,000 to $15,000 for the probate attorneys, filing fees, court appearances, etc. And so if you want to make sure that your assets go to your spouse more quickly, we have a couple different options. You could do joint tenants rights of survivorship for your house. When you co-own the property together, even if you are married and you hold it as tenants in common, your half of the house will have to go through the probate process before it can be distributed out to your spouse. The problem is going to be any assets in the probate process, your spouse does not have access to them. So if your half of the house is going through probate, your investment accounts are going through probate, your cash accounts are going through probate, whoever that might be, they cannot access those assets to sell them or pull money out of them so that they can take care of themselves financially when they have lost your income or your asset management, because it's likely you're the person who's managing the finances. With joint tenants rights of survivorship, when you co-own that property together like that, when you pass away, all they have to do is file a survivorship affidavit and a death certificate at the county clerk's office, and then they will process that and pass your half of the house down to your surviving spouse and avoid the probate process. Now, the other way you can handle the probate process and avoid it and pass these assets down to your spouse is using a revocable trust. You would put all of your assets inside the revocable trust. When you pass away, you can keep the assets inside of the revocable trust, use those assets to take care of your spouse for the remainder of their life, and then distribute those assets out to your kids when they have passed away. The real benefit here, there's a couple, is that you avoid the probate process 2 times. So you avoid it when you pass away, and then your assets also avoid probate when your spouse passes away and you're distributing them out to your kids. The other benefit is that it's likely that you are the one who manages the finances for your family. And if you pass away and distribute those assets out to your spouse when you pass away, they will have to figure out how to manage those assets. And it's likely that at the end of their life, they don't feel like figuring out how to manage those assets. So the benefit of the revocable trust is that you put the assets in there. Your trustee that you choose, it can be a kid, a family member, or a professional. They would manage those assets on behalf of your spouse. That way your spouse doesn't have to figure out how to manage them, but they can still be taken care of with the assets inside of that revocable trust. Big benefit there. In terms of what the probate process is going to look like when you pass away without a will, the person who's going to be the administrator of your estate, it's a first come, first serve, whoever wants to do it. They will go get your death certificates. They will take that death certificate along with the petition for probate, file that at the probate courts in the county where you lived. The probate courts will open up the probate process and give them letters of administration, which gives them the authority to manage your assets in the estate during the probate process. At that point, they will go to all the institutions that you have accounts with, things like your utility company, taxes, bank accounts, investment accounts, etc. And they will give them the death certificate and the letters of administration and capture all of those assets and put them inside of your estate for the probate process, or they will give them the letters of administration and be allowed to start managing those assets, things like utilities and property taxes, etc. Now, the other thing here is that they're going to have the ability to open up an estate bank account so that they can transfer all of those liquid assets into your estate during the probate process. At the same time, they're also going to publicly notify creditors that you have passed away. And then those creditors are going to come to them and say, hey, this individual owes us money for these debts that they had with us. That administrator of your estate is going to start getting rid of liquid assets to pay off those debts, things like your investment accounts, etc. If there are not enough liquid assets inside of your estate to pay off those debts, they'll have to start selling off physical assets, things like your home, cars, boats, etc., to pay off those debts. Now, if there are not enough assets inside the estate to pay off all of the debts, it will literally wipe out all of your assets and leave your family with none of them. But if there are enough assets inside the estate to pay those debts off, then they will distribute the remaining assets to your beneficiaries after they have paid off those debts. Now, again, once we're at the point of distributions, they're distributing the assets per the intestate laws. So your spouse will get a minimum of 1/3, and those assets are going to get split between your spouse and your kids. If you want to avoid the probate process and you want to make sure that your spouse is getting all of your assets to take care of them in the end of their life, click the link in the bio, fill out the form, and schedule a time to talk to some on our team.